everyone, and welcome to today's Bristol Law Society webinar. I'm Ben Holt, immediate past president of Bristol Law Society and a commercial litigation partner at BWV. I'll shortly hand over to today's guest speaker, Mark Beaumont of Annecto Legal. Annecto Legal are one of the UK's leading commercial litigation funding and ATE insurance brokers. And as you're all hopefully aware, advising clients on funding options is a necessary part of our advice and litigation work. And perhaps more importantly, I've known Mark and his colleague David Law for many years, and they're very nice chaps. And I think they're both going to be at the Bristol Law Society summer party. If any of you are going there, I'm sure they'll be delighted to have a good old catch-up chin wag. They've also been great supporters of Bristol Law Society for a long time, so thank you for that. Mark's going to be talking to us today about variety of retainer options available for litigation and how to use them to attract and retain clients, as well as maximising inter-party recovery and looking at alternatives to hourly rates, including CFAs and DBAs. This session is going to be recorded as usual. It'll be on our YouTube channel if you've got colleagues who are unable to make it today, and I'm sure the slides will be shared after the event as well. If you've got any questions to pose, please could you put them, probably best to put them in the Q&A function, and I'll pick those up at the end to ask to Mark. Otherwise, I've got to think of some questions, so please do put some down, or I'll think of something really tricky for Mark to try and catch him out.
So we're going to be talking about maximising inter-parties recovery of hourly rates, your obligations to your clients, and then we'll get into the different types of retainers and how you can use them and explain them to clients. So some of this will rattle through pretty quickly. We'll spend a bit more time focusing on other areas. Obviously, if there is anything that you feel I've brushed over a bit too fast, feel free to drop a question in, as Ben says, and we'll go into that a little bit later on. Or if you've got something very case specific that's not really something you want to talk about in the group, feel free to drop an email and we can have a separate conversation about that. That's absolutely fine. So hourly rates, one of the most important things here is to actually cover these off in your initial CFA and client care letter. I know that sounds obvious, but the amount of challenges we see to retainers and to solicitor-owned client bills because of the way that this has been dealt with at the outset, or not dealt with at the outset, more importantly. On many cases, they can run on a lot longer than you anticipate. So whilst the hourly rate you enter into today might be appropriate, if the case is still running in 2, 3, 4 years' time, that might not be the most appropriate hourly rate anymore. So it is worth just putting a provision for review in there and actually consider reviewing your hourly rates on all your cases or across your department, across the firm on an annual basis, because there may well be cases in there that have been running for a significant period of time that should really have been updated. Obviously, if you are updating the hourly rate, it's important to mention that to the client, have a conversation with them about it and make sure that's all agreed. But obviously, if you haven't agreed it with the client, you can't recover it from the other side, and it reduces your inter-parties cost recovery if you're operating to the wrong hourly rate. The guidelines were updated relatively recently. So these are the present guidelines we're all working to. Should be stressed that the guideline rates are generally viewed as being for fast track matters that are set down for a day or less. So when you think about most commercial disputes, certainly, that's not really reflecting the reality of what you guys are doing. So use these very much as a guideline, you know, what it says on the tin. These are not written in stone and handed down from a mountain somewhere. You can move away from them. And we'll talk about the circumstances where you can do that. But in essence, it's the value, the importance, the complexity, the amount of skill and effort required, the time spent, and any particular circumstances that are relevant to the case. So there's a lot of good reasons there. Aside from the fast track matters that are set down for a day or less, there's a lot of good reasons to be moving away from guideline hourly rates. And if you're performing any kind of specialist work around insolvency, professional negligence, whatever it might be, you can make a strong argument that because you specialize in a particular area, you're going to perform the work faster than some non-specialists might, and you shouldn't really be passing that saving onto your opponents as part of the inter-parties cost recovery. You should be able to charge a higher hourly rate to reflect the fact that you're performing the work at a faster pace. And we've seen recent case law talking about partner time, and where in boutique firms, partners are spending much more time on a case, could be over 40, 50, 60% of time on a case could be partner time, and where that can be justified on the basis of the complexity of the matter and the fact of a lack of duplication of the work as well. The last point there is the last agreed budget. So if it is a case that's being budgeted, do make sure that if there are changes to the hourly rate, changes to the amount of time being spent, that the budget is updated and you've asked the court to approve that. Obviously, we all have obligations to our clients. They're very clear for solicitors, which is that you really should be discussing whether the own client's costs could be paid by someone else. That could be a before the event policy. It could be under a different form of retainer agreement. It could be third-party funding. There's a whole raft of different things that could fall under that clause. But it is important to mention to the client that these might be options. You don't have to necessarily say that you would offer those options, but that they could be available to the client and that they could be explored. The risk of not doing so was highlighted very much so in Adris versus Royal Bank of Scotland, which I'm not going to get into today, but needless to say, the client wasn't advised that ATE was an option, and it proved to be a very expensive claim against the solicitors. We moved 12 years ago now towards outcomes-focused regulation rather than indicative behaviours. Excuse me. Or indicative behaviours as well, sorry. So what this is about is, what are you doing to actually assist your clients? Are you helping them to achieve the outcome that would be most appropriate for them? So this will be about discussing the specifics of how the case is funded, how it's insured, basically how the project is being risk managed and financed. I think one of the things we see on litigation time and again is, clients are in a position where they're litigating under duress. Often time is focused on providing legal advice, getting the case moving, solving the problem for the client, but perhaps less time is spent looking at the risk management, the finances, the cash flow, the things that actually could be just as or more as important to the client themselves. And it is important to spend some time just focusing on that, making sure the client does understand what types of tools might be available to them. There are very few projects that individuals or businesses enter into that are going to cost tens of thousands, hundreds of thousands, potentially even millions of pounds, where they don't consider how best to use insurance, how best to use financing, and how best to manage their risk around a project of that size. So just take a moment to actually think about that before you progress with the project. Obviously, when it comes to retainers, there are multiple kind of conflicting sometimes interests at play. You're trying to help your clients. You want to achieve the best outcome for them. Obviously, from a business point of view, you don't want to take on too much risk as a law firm. You don't want to take on too much risk as a fee earner. But then there's also a tension between risk and reward. You may have cases that you do want to take some risk on under a conditional fee agreement, for example, because you want the benefit of the reward that comes from being successful in those cases too. So think about what you're trying to achieve. Obviously, under a private paying hourly rate basis, the kind of standard model, if you like, it's good for cash flow for the law firm, not so much for the clients. As a consequence, does the cost and the risk to the client actually reduce the amount of cases that might be progressed? And of those cases that do progress, does it reduce how far they go? A client's more inclined to perhaps undersettle or early settle cases where it's expensive and risky for them than perhaps cases where they're investing less in it directly themselves and can pursue it further to get a better outcome. Clearly, it also restricts the hourly rates that you can charge under a private paying basis. We talked about the guideline rates and how you can potentially increase those using those 7 pillars of wisdom, the arguments to move away from the guideline rates. It's a lot harder to move away from guideline if the client's paying it rather than being under some kind of conditional fee agreement. So obviously there's commercial pressures there, and the client might choose to instruct another firm if they see your hourly rate as being too high. And just a final point I'd say there as well is, there are lots of work that goes on a piece of litigation that sometimes firms are reluctant to actually bill the clients for at the end of the month. And what you find is that perhaps things that could have been recovered on an inter-parties basis are restricted from doing so because the client was never billed for them. The law firm perhaps took a view that they'll restrict their hourly rate to keep it commercial. They'll restrict what they bill their client for to kind of treat them fairly, if you like, not 10, 20% off an invoice at the end of a month because they're a good client. Well, these are all things that therefore can't be passed on to your opponent at the end of a claim as well. So there are pros and cons from that kind of traditional model. Under a conditional fee agreement, that's where it's based around the time spent on the case. So it's still an hourly rate model, if you like, but the fees are deferred until the successful conclusion of the claim. So the law firm is taking more risk. They're running the case without being paid any cash flow during the lifetime of the case. It's obviously better for the clients from that point of view in terms of what they have to spend on a day-to-day basis, but it's very bad for cash flow and more so, of course, if you lose the claim. It does allow for more cases to potentially be taken on because that obstacle to clients of pursuing litigation, which is cost and risk, is moved out the way. And so the clients can potentially instruct on claims that they perhaps might not have done if they'd had a big bill to pay. And it can be tactically useful. If the other side knows that you're investing in this case directly, you've obviously seen sight of all of the papers, you've taken a view on whether this is a good claim to pursue or not. The other side might read into that obviously more than they do, and perhaps this is a much better case than they were aware of. And when I was talking just a moment ago about restricting what you can recover on inter-parties basis, time recording is really important under a CFA because you want to make sure that you record all of those things that you're doing on the case that can potentially be recovered on an inter-parties basis. So anything that allows for the case to progress, so anything that's not real kind of client management stuff, are things that could be recovered on an inter-parties basis. So make sure you time record properly, and there's no reason to be discounting those at the end of the month. Is there a better option? Well, I wrote these slides, so I certainly hope so. Well, that would be a weird intro. So discounted CFAs. I think a lot of people stopped using these post-Jackson on the basis that you couldn't recover success fees anymore, and it was seen that they were less useful. I think that's a misunderstanding of what discounted CFAs can do. So a standard CFA is no win, no fee. A discounted CFA is no win, some fee. So rather than under an hourly rate model where you're being paid your full hourly rate, or under a full CFA where you're being paid nothing, a discounted CFA or a hybrid CFA, a partial CFA, there's various names for them, means that you get some of your hourly rate cash flowed during the lifetime of the case. If the case loses, you've been paid that money and you keep that. If the case wins, your hourly rate would be made whole and you could potentially recover a success fee as well. Now, it's important to differentiate between the win rate, your hourly rate under a discounted CFA, which is recoverable on an inter-parties basis, and the separate success fee, which is a percentage uplift on that win rate, which is not recoverable on an inter-parties basis. I therefore think it's worth considering how much of that success fee, if you like, could be shifted more into an hourly rate. And what I mean by that is there's no point in running a case on a low hourly rate with a high success fee if you could have recovered a higher hourly rate from your opponent upon success. You're not benefiting your client by having a low hourly rate and a high success fee. You are benefiting your client if you have a high hourly rate and a low success fee, because you're recovering much more of that overall time from your opponent. People think of discounted CFAs most commonly in the context of would they do a CFA on the case? And that makes sense. I think there's another scenario as well where you can consider discounted CFAs, and that's on any piece of litigation. Any piece of litigation where the client is willing to pay you an hourly rate, which is lower than the hourly rate you might be able to recover on an inter-parties basis. And that will be an awful lot of litigation. So there'll be commercial pressures on your hourly rate that mean you offer clients a certain level. It could be on pretty much every claim you run, you could be charging more than that normal hourly rate you charge to clients, given what a court would allow for your specialist skill or the types of claim you're doing or how important it is to the client. So I would say on any claim where you can see a difference between what the client is willing to pay you and what you might be able to get back from your opponent, consider whether a discounted CFA is a good route to go down. That way, if you're only billing your client during the claim for a lower hourly rate, you can interim invoice them, you can time record for all of the stuff you might not necessarily want to bill them on a monthly basis, and you can time record all of it at the higher hourly rate. And if you're successful in the claim, seek to recover all of that from your opponent. Now, you might not get all of it back from your opponent, but you're more than likely to get more than what you would have been if you'd tried to just recover your standard hourly rate that your client is paying. Obviously, we need to be careful about the indemnity principle. So what you do is you limit your charges to what your client gets back at the end, basically. So you're never charging your client less than what you recover back from your opponent. What you're saying to your client is, you pay me this during the case, say £300 an hour. If we're successful in the claim, I'm going to seek to recover £500 an hour. You are liable for that £500 an hour, just as our opponent is, but we will cap your liability at whatever we get back from the other side. So at no point is the other side liable for more than your client. It just moves in lockstep. So you're never breaching the indemnity principle. Obviously, the wording around that is very important. And another thing that's very important as well is around invoicing. What you don't want to do is interim invoice your client statute invoice your client for the full amount they owe you at the end of the month. So say they're paying you £300 an hour. You don't want to invoice them as a statute invoice for £300 an hour at the end of the month. What you want to do is get a payment on account or an interim invoice paid for £300 a month, making clear they're still liable for that £500 an hour and any additional charges you haven't billed them at the end of the claim, if successful, because that way you can pass on those charges to your opponent. And as I say, you just cap your client's liability at what you recover from the other side. So it's important to have that conversation with your finance department, make sure everyone's joined up on that and nothing falls through the gaps. But it's certainly a useful tool in the sense of recovering more for your client. You know, if you charge your client £300 an hour and get 70% of that back at the end, the client's losing out because you're likely to deduct the remainder from any damages they recover to make yourself whole for your hourly rate. If they're paying you £300 an hour and then you're seeking to recover 500 from the other side, well, let's say you get 400 back. The client's getting 100% of their costs back because they've only been paying you £300 an hour. So it's a much better position from the client's point of view. It means you're not taking on as much risk on a full CFA as you would have been. It's a great business development tool in being able to go out into the market and talk to clients about how you can share risk, how you can cap their liabilities, how you can make life easier for them. Obviously, we've talked about the increase in higher hourly rates and more billable time. And I think another thing as well is it can be used in conjunction with things like fixed fees. So you might choose to use fixed fees on a phased basis through the litigation. Your fixed fee could be your reduced hourly rate, if you like. So instead of offering someone £300 an hour, you could say, look, we'll cap our fee at £6,000 for this particular phase of the work. If we're successful in the case, the real charge is £10,000. And again, it just moves in exactly the same way as we talked about before, just being careful not to breach the indemnity principle. Clearly, what you don't want to do is get a great win for your client, but fail to actually meet the definition of success in your own CFA. So how you define win in any CFA agreement is really important. And I would stick with a pretty wide definition of win, something like we've put here, you know, any way that the client derives benefit from pursuing the claim, because you want to make sure that you're able to recover that higher hourly rate from the other side. You can still charge a success fee as well on top, by the way. It's just because that's not recoverable inter partes. That's something that has to be very much agreed between you and your client and will definitely come out of their damages. Talking about fees coming out of damages, obviously damages-based agreement is something that came in, nearly 10 years ago now, hasn't been massively utilised. Some law firms have really embraced it, but I'd say the vast majority have been reluctant to do so. I think there's an element of how the rules were drafted there that's made people somewhat reticent about embracing them. But I think there's also just elements of, you know, fear of change and doing things differently. We're all used to working under the hourly rate model, and the CFA model is at least reflected in that, that it's still based around hourly rates. It seems more comfortable for people. I think that's safe to say. I think where DBAs become interesting is it completely breaks the link between hours worked and fees recovered. So, traditionally, the only way to really grow a department was to have more people, or, people working harder, doing more hours, clients paying for more hours of work. Damages-based agreements can completely change that. It's all about what you recover back for your client, not how many hours are worked on a case. So I think when people tell me, oh, our client's not really interested in this, I find that somewhat surprising. And I do wonder how the clients were presented this, because in my experience, a lot of business people very much like the idea of paying based on what they get out of a case, rather than paying for any number of unlimited hours that might be done on the case over any unlimited period of time. Having no correlation between what you as a client get out of a case and what the lawyers get paid is a huge misalignment of interest. And I hear people talk all the time about conflicts of interest around DBAs. I would say they're a much closer alignment of interest than the traditional hourly rate model, which creates a massive conflict between the solicitor and the client. We're being honest, it's in a solicitor's interest for a case to go on forever, and the hours to keep being billed forever. Now, I'm not saying anyone does that, because we all work as we should do and act professionally. But I think it's crazy to say that there's no conflict of interest under an hourly rate model and there are conflicts under a DBA. I'd say, if anything, it's probably more the other way around. So I do think DBAs can be of interest to clients. They don't have to be used for an entirety of a case. You could say that you'll run a DBA up to, say, the point of issue, or maybe up till CMC. And then if the case goes beyond that point, you might want to switch to a CFA, for example. But actually spending time thinking about retainers and thinking about what clients might want from retainers can be a really useful business development tool. And I think if you're not putting in alternative funding models, damages-based agreements, contingency fees, whatever you like, into your marketing material and having clients actually engage with you on that basis, I think you're missing a trick, because we see a huge amount of clients searching, looking for lawyers that are willing to talk to them about these things, because they think it might be a good model for their claim. Now, whether it is or it isn't, that's their starting point to engage with lawyers. So it may be something you want in your marketing material, just to give yourself the opportunity to have that conversation with a potential client and see whether it's the right model to use or not. But just getting into the detail of DBAs, so it's a DBA, you get the percentage of the damages recovered. So I've just used an example here to just show where you need to be a little bit careful. So say you've agreed a 25% DBA with the client, they get £1 million back, you get paid £250,000, which is 25% of £1 million. You also get back separately £220,000 of costs. Well, that £220,000 is not part of the damages, so it's not part of your agreement, it's not part of your share, if you like. That belongs to the client. So the client would be getting £1 million, give £250,000 to the solicitor under the DBA, and then would get £220,000 of costs. So their walk away is actually £970,000. Where you then need to think about is, okay, well, what happens if the costs have ended up being £400,000 or £500,000? You're going to walk away with £250,000 because that's 25% of £1 million. You could actually be out of pocket if you spent a lot more than that on the claim. So typically, where we're looking at DBAs with solicitors, a starting point is your expected damages on this claim 10 times what your expected costs are on the claim? If that metric exists, then you can think about what an appropriate level of DBA percentage might be and things like that. If the claim's closer than that, if the claim is, say, worth 3 or 4 times what the likely costs are, I'd just flag up a word of warning, because the experience all of us have in cases is that damages tend to come down whilst costs tend to go up. So if you're starting off with, a small amount of headroom between costs and damages right the way from the outset, it just creates a bit of a red flag. And certainly when you're talking to litigation funders, that 10-to-1 model is something they've moved towards over a period of time. Remember when I started out, it was more 3-to-1, 4-to-1 was the kind of cases they were looking at, but they learned the hard way that actually that's where problems arise. Sorry, just keeping an eye on time. Think about what falls under the cap as well. I think the general understanding is that counsel fees and VAT and ATE premium do fall within the DBA cap, whereas any kind of external fees, such as a third-party funder's fees, might fall outside, which does create the opportunity to perhaps build a funder into the claim as well if you need kind of disbursement funding or something like that to run the claim on the DBA. The Hodgson immunity for solicitors and the Arkin principle for third-party funders, they do still exist, so it does cap your liability for adverse costs under a DBA. Although Arkin has been somewhat weakened, where the third-party funder stood to gain hugely out of a claim and the claim was underinsured, third-party funders have found themselves as a consequence on the end of a third-party costs order for perhaps significant amounts of money, and they could actually find themselves on the hook for perhaps more than they've even invested in the claim. So that is a risk that funders run, and that's why insurance needs to be properly thought about when you're running these types of cases as well. Third-party funding. So if you run a discounted rate on a CFA, obviously the client could be paying you that discounted rate during the lifetime of the claim, or you could bring in a third party to finance that. What that would mean is obviously the client's not contributing as much or potentially not contributing anything and might be able to run a claim that they couldn't afford to run previously, or can run a claim for longer now to get a much better deal out of it, rather than potentially having to undersettle something because they are short on cash flow or they can't meet the security for cost requirement or whatever it might be. Again, tactical advantages about bringing in a third party to finance a claim can be very high. You don't necessarily need to get a third party funder in to fund absolutely everything. They could be funding part of your hourly rate. They could be funding just disbursements. They might be funding just, say, an upfront ATE premium or a security for costs product. There is a huge degree of flexibility around what you can bring in funding for on a claim. And obviously the aim would be to bring as little funding in as possible, typically, because you want to retain as much as you can for the client. And obviously the more funding you bring in, the more you're going to have to pay back to the funder plus their success fee. And that's not recoverable from the other side. I've mentioned that ratio of cost to damages, that 1-to-10 model. That's something that's fairly generic across the market. It doesn't need to be that high if you just need ATE insurance or a security for costs solution or perhaps disbursement funding. There are models you can use where, if it is a 1-to-3 ratio, 1-to-4 ratio, you can probably still make it work. But the narrower that gap gets between the costs and the damages, just the less headroom there is to pay out success fees to you, to funders, to insurers, and obviously the less then the client could potentially walk away with at the end. Other metrics that funders will be considering, and frankly, clients should be considering, and you should if you're taking on any risk on a claim, is this a claim for damages? Is the other side actually good for the money? How much is it going to cost? How long is it going to take? And what might you get back at the end? These are commercial decisions that need to be taken around disputes. Is there likely to be a return on investment for all the parties involved? I get that for some clients, they may wish to pursue a claim anyway. Even without that return, there could be important business reasons for doing so or moral reasons for doing so. But typically, if you're getting involved, if funders are getting involved, if insurers are getting involved, these kind of commercial metrics are going to be hugely important. Other things to think about: does the client actually have the money to pursue the claim, or does the defendant have far deeper pockets? Now, clearly, there's an issue there if the client just doesn't have the money to pursue the claim. That's going to be a problem, and you will need to find an alternative retainer solution or an alternative funding solution to do so. But even when a client does have cash to pursue a claim, if the defendant has far deeper pockets, what they may do is actually not defend the claim directly as such, but just attempt to make life very, very difficult for you. And that could be by bringing lots of applications, security for costs, taking you off around the houses with the litigation, dragging it out for as long as possible, really trying to exhaust your client financially to make it hard for them to see this case all the way through to the end. And I think where defendants don't have necessarily a great legal standing, a great legal case to defend the claim, these are obvious tricks they use. And I see now, professional negligence claims where there's lawyers on the other side who represent lots of insurers. They're used to claimants bringing claims where there's ATE, where there's potentially funding or CFAs involved. And I see a lot of their letters now very much geared towards not just the actual claimant themselves, but trying to put a wedge between the claimant and their own ATE insurer or funder or solicitor, trying to put that doubt in there to make life difficult, because they know that if they can stifle the funding, it actually stifles the claim, and that allows them to win cases that perhaps they wouldn't have won on the legal merits alone. And by winning, I mean either getting rid of the case in its entirety or being able to settle it for a much lower amount of money by scaring off, funders and insurers, if you like. It's important to be completely upfront at the outset with funders, with underwriters at insurance companies of what the strengths and weaknesses of the claim are. If you don't want to be seen as having hidden things from them that might come out of the woodwork later on. And obviously, if they know what the potential risks are of the claim and still back it, that puts you in a fantastic position and makes it harder for defendants to do this type of thing at the end. We see a lot of businesses now where they just don't want to invest their own money in litigation. And there are really good reasons for this. If you think about any business that accounts using a pretty standard EBITDA model, if they've budgeted for their year and then they find that they have to spend additional money outside of their budget in order to finance legal fees, there's only really one place where that money can come from. And that money is going to be coming from their bottom line. It's going to be depressing their profitability for at least that year and potentially into a second year, maybe even a third year on some larger scale litigation. The consequence of that from a business point of view is that if you reduce your profitability, even if the claim is successful and you ultimately win and make a financial recovery and recover back some or all of your legal costs, you could still, in that scenario, have put your business in a worse position than if you'd never run the litigation at all. And the reason for that is a depressed profitability for a 12-month or a 24-month period has a knock-on effect on your profitability, on your EBITDA, on your ability to raise finance, on your share value, your profitability to your shareholders, your ability to pay out dividends. It has all of these longer-term implications that are not rectified by simply winning the litigation, because those legal costs come out as an actual cost on your accounts, whereas any one-off recovery you make from litigation is treated just as that. It's treated as a one-off exceptional item. It doesn't repair the financial damage done to the business accounts from spending money on legal fees. So you can have a business that actually has cash flows fine, not a problem at all, but would still prefer to shift any kind of litigation cost and risk off of their own balance sheet onto, say, a third-party funder or onto an insurer, or indeed onto your balance sheet with a CFA, because it benefits them in ways that are perhaps unseen to most litigators. This is why I think it's important to be talking to your corporate clients, talking to your professional referrers, such as IFAs, accountants, about the tools available to shift risk during litigation, because it actually open the door to clients to being able to pursue things that just wouldn't have made financial sense for them to pursue on their own balance sheet. And obviously any money they're not spending on legal costs, they can spend elsewhere in the business, either as paying out on dividends, improving their profitability, investing longer term in the company. And even a really good legal case, you're only giving it 65% chance of success. A lot of businesses will look on their return on investment from that and think, you know what, I'd rather spend this money on something I know I can get a return on, such as recruiting, investing in IT, investing in equipment, offices, sales expansion, whatever it might be. But you're actually reducing your chances of getting work if you're not offering these kinds of tools to the different types of clients that you have. And obviously, access to justice is clearly important as well. It's just that the commercial rationale for this is probably going to be more prevalent in most of the types of cases that we're looking at. So I've rattled through this pretty quickly. I hope there's going to be some questions on this. Otherwise, that would have been very fast. But costs and risks are obstacles to clients considering litigation or arbitration. Fee earners, which I find a fascinating term used in the legal sector. In most environments, people are always looking to dress up people's titles in a different way as consultants or executives or something like that. I'm yet to see any other world where people are actually referred to as fee earners, which, when you take a moment to just stop and think about it, does sound like a particularly kind of brutal description for what people's roles are in a business. But it's also the reality. We're all fee earners. And as much as we might like to think that our knowledge and our ability around the law will be the thing that dictates how we get on in our career, actually our ability to earn fees is going to have a much more direct correlation with where we go to in our own career than anything else. So being able to attract clients, being able to retain clients, being able to give clients a good deal, for it to be a good deal for the firm itself, these are all hugely important things to have a successful career, a successful practice, a successful firm. So providing kind of cost-effective solutions to clients is only going to get more and more important. And what we have seen over the last few years is more and more law firms really get good at this stuff, being able to offer a wide range of retainer options to clients, being able to offer a range of different funding solutions and insurance solutions. So clients have the ability to pursue all those different types of cases, and less stuff is kind of being pushed back and rejected. So I think there's little worse than, as a law firm, having the phone ring, having a client that's got a problem you can potentially solve for them, but not being able to help them because it's too expensive for them to pursue it, or too risky for them to pursue it, or they just can't make it work from a return on investment perspective. I think that brings us to the end there. So as I say, I've tried to kind of work through that pretty quickly because I'm very conscious that some of you will be familiar with lots of areas of this. There'll be others of you that, elements of this will be very, very new. So I'm more than happy to kind of spend a bit of time talking about specifics on this if anyone's got any particular questions. And apologies for my squeaky chair, by the way, if that's coming through.
Thanks, Mark. That was great. I don't think I've seen any questions come through yet, but if I can, obviously, pester people to do so. I think there's a function, if it will make anyone feel better about it, that you could just email me, and then I read it out as an anonymous point if there's anyone there who thinks they've got a question that's a stupid question, which it almost certainly won't be. But I'm quite in favour of sort of the webinar approach to having more like Netflix style episode lengths. What's the point of being an hour if you've covered the subject off? No one's going to object to having an extra 5 minutes back. There was one point that it was more of a discussion point really than a question, and it was a thing that I think I read it in the Law Society Gazette this week about I think it was a Court of Appeal decision saying that it basically didn't allow a defendant DBA where there was no counterclaim on the basis that that basically it was I think it was a sort of lose-lose scenario. I think the court described it as a heads I win, tails you lose.
Yeah.
And it just the principle of it doesn't seem right to me. It was obviously, you calculate it on the basis of if you're successful as the defendant, that you don't have to. I don't think it was I don't think it was a straight cash case in terms of just you've got to pay a certain amount of money. I think it was you've got to transfer over. I think it might have been shares, something like that. There's some asset. But why in principle shouldn't a defendant be able to enter into with their solicitor on a commercial basis an agreement that if you successfully defend this claim, we can have a percentage of what you're able to retain? I mean, the principle doesn't seem right, because particularly where a defendant client doesn't have a counterclaim, doesn't have liquid funds, it at least limits the options available to fund the litigation, and it's also, presumably a litigation funder isn't going to be that's not going to be an option either. So I just disagree with the principle of it. And whether you have any thoughts on that?
Yeah, I think in general terms, I don't think there is an objection to using kind of innovative retainage solutions, funding solutions from a defendant's perspective. I think where you need to be careful is just what advice the client's actually taken at the outset, and have they had independent advice on what their options might be, and is this the right model for the circumstances that they face. And I don't want to get into the particulars of any certain law firms or certain DBAs and what have you, because I do know the one that you're talking about there. But I think there are circumstances where the court can quite quickly see where perhaps lawyers have been a little bit sharp and perhaps have been thinking more about their own benefit from an outcome rather than necessary for the client's benefit. So I don't think there's any kind of flat objection to using, as I say, DBAs or third-party funding for defence actions. I think it just needs to be the right tool for the circumstances. And we've certainly seen defendant actions where it's been absolutely right for them to use funding products. In fact, some pretty large corporates have made use of it. And the example I always think of is where you've got like a really large corporate, utilities company or something like that. Their income's relatively fixed in terms of what they can foresee into the future, and often heavily regulated as well, although perhaps these days we don't see quite enough regulation around utilities and what people can charge, but let's not get into that right now. But historically, you would have seen fairly fixed fees, coming in for, let's say, a water utility company, and fairly fixed expenditure as well, because again, quite regulated on what they have to spend to maintain the network and what have you. So they've got kind of a margin that they can see into the future that's going to be relatively stable. However, outside of all of those kind of controlled costs and income, you've got this fluctuating kind of legal spend, which is largely dependent on maybe what actions people bring against you at any one time. And by having that fluctuating legal spend, it impacts on the accounts that no longer look quite so smooth anymore, because that's just impacting on profitability. But if you've got a mix of like claimant actions and defendant actions, you could take all of that and bundle it up as a portfolio, shift that onto the balance sheet of an insurer or a funder, and let them kind of worry about it and finance the lawyers and take an upside. And maybe then all you're seeing as a firm is maybe small elements of upside where cases are successful, but you're not seeing the downside where things lose. Or you could actually pay for an insurance product that says, look, we want to defend all of these claims. We don't have any claimant options to recover funds. We just have to defend all of these claims. We're willing to pay a premium to say, look, we want to insure any potential claims against us for a period of time because we just want the certainty. We want to know what this is going to cost us over a financial period, whether that's 12 months or 36 months or 5 years or whatever it might be. We just want to know what it's going to cost us. And so again, you're engaging in conversations there with funders or insurers and saying, look, what would it cost to shift this risk off our balance sheet and put it on yours? Because there's a benefit to us of being able to do that. But there's, as I say, there's a plethora of different options available. I think the important thing is to consider what are the right options in the circumstances for the client, and to have the client really think about what do they want to do. And if there's been a real back and forth there with a client saying, look, we cannot afford to do this ourselves, we need an alternative. The options we're considering are third-party funding, the options we're considering are a DBA, and then you get into dialogue with them about what they might cost and what they might look like and the appetite for funders to get involved and things like that. As long as that's all happened and the client's made an informed choice about what to do, I think it's very difficult for the client to complain at the end or a court to step in and say, this was the wrong thing. I think it's where that dialogue didn't exist and the client feels they've been forced down a particular route where you're going to get problems.
Thanks. We've had three things pop into the question and answer. One, I'll just deal with one quickly because it was just, Mark Heath just noted a sensible point. I don't think this is a point for you to particularly respond on, Mark B, but Mark's just saying please do be open with chambers on what solicitors' funding deals are on, as most chambers will be opening to mirroring the solicitors' retainers. Thanks, Mark. That's a good point.
I think, sorry, just to add on to that as well, Ben, I think one of the things where solicitors miss out is they just say, oh, counsel don't do CFAs. And I think most funding deals involve a partial CFA. And I think there's a big difference between just saying to a clerk, would you do a CFA, or approaching a clerk and saying, look, we're on a deal here where, you know, the funder pays us 60% of our WIP at the end of every month, typically paid within 48 hours. You know, would counsel consider doing that, knowing that if we're successful in the claim, they get 100% of their time plus an uplift as well. Actually getting, say, 60% of your fees paid sharply at the end of every month is probably more attractive than a lot of standard hourly rate cases where you spend 6 months chasing invoices around the world, you know, trying to get paid on things. So I think how you present these things can be important as well.
Thanks. Question, to what extent do you think that there's a conflict of interest between clients and lawyers when negotiating these financial arrangements, and how should it be addressed? When does a client need to take independent legal advice? You obviously briefly touched on this.
Yeah, well, I think there's a conflict of interest on every single retainer option possible. There just has to be, because the clients are either paying for like an unlimited amount of time being done on the case on an hourly rate model, or they're paid on an outcome of what they recover in the damages, where, you know, their interests are aligned with the solicitor to some degree, but you could say, well, you know, an early deal might be better for the solicitor there before they've spent a huge amount of time on the claim, rather than, you know, taking something all the way to trial and carrying that risk as a law firm that you might lose and get nothing. So I think there's always a conflict of interest. I don't think there's any desire typically within the industry to go and get clients to get third-party advice when they enter into an hourly rate model, because we're just used to it. But, you know, if Lord Justice Jackson had come along 10 years ago and said, look, guys, you've all been doing contingency fees, DBAs, for 200 years. We're going to move to this new model where instead of a client giving you a share of whatever they get back from damages, they're going to now pay you for every hour of work you do. And the more staff you put on a case, and the more time you spend on it, and the longer the claim runs for, and the more appeals they are, the more you get paid on the claim. I think people quite rightly would have gone, this is madness. You know, this is a huge conflict, you know, to move to such an hourly rate model. It's only the fact that it's always been like that means that we don't see the conflicts there. So that's one thing I would say. I think the second thing is, I think if you've gone out and approached, say, a funder or a insurer or a couple of people and come back to the client and gone, this is the deal, I think you do run a risk there, because you haven't really explored the market, and the client is potentially relying on you to get them a good deal. And you don't want to be seen as advising around any particular funder. You don't want to be seen as being recommending any particular insurance product. So I think just be careful around those issues. I think if you're going,
wouldn't that be? I think that's possibly a breach of our obligations under dabbling here, but it's FISMA or something. I don't think we're allowed to recommend investments in a particular.
Yeah, exactly. Yeah, yeah.
We have to go through brokers like yourselves.
Well, yeah, I think technically there are ways of approaching this. I think if you've gone out to a wide array of the market directly yourselves and presented those options to the client, and the client's made their own choice, I think you can kind of work around that. So I don't think you have to use a broker as such, but I think you almost have to take on that role yourself and do it properly if you're going to do it, and make sure you're not recommending anything to the client. So I think there's an element of which is easier, frankly, from a lawyer's point of view, you know, loads of non-billable time dealing with funders and insurers, or just getting somebody who does it on a day in, day out basis to go out and do it for you and making sure that you're compliant with all your regs. I think there's certainly that view to be taken. But I think then it's about how are the options presented to the client? You know, is the client being put in a position to make an informed choice about how to proceed with the litigation, or are they kind of being forced down a particular route that suits the legal team, perhaps? I think there's a big difference between those two things. But typically, you know, we would see clients go off and we would encourage them to get independent advice on the wording of a funding agreement, the wording of an ATE policy, and also just to make sure that the documents don't conflict. Because typically, if you're entering into a funding agreement, you're going to have a discounted CFA, certainly with the solicitor, potentially with counsel as well. You're going to have a funding agreement, and you're going to have an insurance policy. Now, all of those documents need to work in their own right, but they also need to work in conjunction with one another. So are their definitions of success comparable? Are their triggers for payment comparable? is any one document trying to take priority over another one, or both trying to take priority over each other? Those are the kinds of things that I think need to be explored, and just making sure that the client doesn't open themselves up to some kind of new liability that they weren't even aware of and didn't have before entering into those agreements. So I think it is important that they get independent advice. And I think there's probably a handful of people we use on a regular basis where we say, look, these guys they understand funding agreements, insurance agreements, and equally, they're not in the market to rewrite them. What they will do is give you good, sensible commercial advice that you can make practical choices on. They're not just going to start moving commas around in an agreement, which, frankly, if you go to the wrong kind of people, they'll just start rewriting agreements, but without really giving you any advice on anything.
Yeah. Just with an eye on the time, I was keen to make sure we deal with the last question that was kindly put forward. Before the event, insurance and payments by insurers of rates way lower than the usual rates. Do you have any suggestions on how to increase those?
So I think be aware of what the client's rights are when you're engaging with BTE insurers. So I think most BTE insurers would want you to believe that the clients have virtually no options at all about how to proceed when they're engaging with a BTE insurer. And that's certainly not what case law and what the regulations say. So clients do have quite a bit of freedom. So as long as you're not increasing the liability to the insurer, you can pretty much do what you want, frankly. So you could use a BTE insurance policy to act as a payment under a discounted CFA, for example, because you're not increasing the liability of the insurer. You're just using it as a way to extract maximum value from the opponent if the claim is successful. If the claim loses, the BTE insurer is not paying any more money. Also think about when to consider additional forms of funding and insurance. So we see a lot of policies where there's 100K cover, and you might take the view of 50 for own costs, 50 for adverse costs. If the claim doesn't settle basically immediately, you've got a problem then of, well, what happens when that money runs out? You're far better off thinking about that problem very early in the process, when you've still got money in the bank, if you like, rather than when it's all been spent. The worst thing is when a client comes to us and they say, either we've exhausted a BTE policy of £50,000, or we had 50 grand to spend on this litigation, but it hasn't settled, so now we're broke. Can you get us funding? You go, well, hopefully we can, but it kind of depends what you've done with that £50,000. Have you gone off and explored, whether the other side has assets, if that's a necessary part of the claim? Have you explored what the actual loss is? Does that need quantifying by specialists? Have you got external legal opinion on the merits of the claim if it's a complex legal issue? Have you budgeted this case through to trial? Does it actually work economically? If you're talking about a claim worth £150,000 and the budget to trial is £120,000, probably not. You really needed to settle this pretty quickly for whatever amount was available on the table, really, because there's no way you can take it to trial. No one's going to fund that. So it's what have you done early on in the claim that allows you to take alternative steps around retainers and funding and insurance if the BTE policy isn't enough to actually get you to a settlement.
Brilliant, thank you. Well, we're spot on 2 o'clock, and I'm sure the numbers will suddenly start dropping off anyway. So thank you very much, Mark. Another excellent session, and hope to see plenty of you on tomorrow night at the summer party at 0 degrees.